and has substantially affected the way the victim feels about her safety and security at the home, which I think is very important, Your Honor, to acknowledge that.
I'm sorry. I'm getting. What's that?
Are you going to allow?
No, I'm talking to you. Why are you taking her up? You're not. Okay.
Because I don't want to be in here.
Staying in.
Requested to leave.
Oh, you're bringing the chair in. Okay, that's fine. I apologize, Mr.
No,
That's fine, Your Honor.
I was getting signals from the defense.
That's fine. I also would point out to the court that the unlawful flight from law enforcement.
I stand by. Apparently they're gonna restrain her and bring her back in.
Welcome back to your favorite YouTube channel where no one is above the law. Today we are covering a sovereign citizen by the name of Miss Shayna Marie Blackshire. Miss Blackshire seems to have a huge contempt for the courtroom, for the judge, for the officers that's working in the courtroom, for the victim's family. And I just want to know, what is going to be Miss Blackshire's argument? Is it going to work out? Is it going to help her case? Will they be able to contain all of the energy and contempt and anger that Miss Blackshire has for the court? There's only one way for us to find out, and that's for us to roll the videotape.
No, come on out. This is the date and time set for sentencing. The records show the presence of the defendant. Our advisory counsel is here. Mr. Wagner, are you appearing before the state?
Yes.
This is the date and time set for sentencing. Good.
Excuse me, how you doing?
No, I'm talking now. Listen to me. Is your true name and your complete name Shayna Marie Blackshire?
The court lacked jurisdiction over the subject matter.
What is your date of birth?
The court lacked jurisdiction over the subject matter.
The court will accept the court, based upon a verdict by the guilty in this case.
The court lacked jurisdiction over personal addiction.
As a result of a jury trial, the court finds the defendant is guilty in CR 22209. Count 1, unlawful flight from a law enforcement vehicle, a Class 5 felony. This is in violation of ARS 28624C, ARS.
Y'all cannot force me to get sentenced.
Yes, I can. ARS 28622, ARS 28622.01, A1, 28624C, 283001, 283304, 283305, 283315, 13701, 702, and 801. The date of the offense was on or about February 5th, 2022. The offense is non-dangerous, and I'm finding it non-repetitive for reasons I'll state on the record. Count three, that she is guilty of count 3, criminal damage, a Class 1 misdemeanor. It's in violation of ARS 13-1602A1, 13-1601, 13-707, 13-802. And she's also guilty of count 4, burglary in the second degree. This is a Class 3 felony in violation of ARS 13-1507A, 13-1501, 701, and 702, and 13-801. The date of the offense was on or about February 5th, 2022. Judgment of the court that she's guilty of count 5, resisting arrest, a Class 6 felony in violation of ARS 13-2508, A1, 13-701, 702, and 13-801. The date of the offense was on or about February 5, 2020.
Excuse me, advisor. Why is they allowed to do such things?
2022. The offenses are non-dangerous and non-repetitive. The reason I'm finding them is the microphone off, Louis, by the way. Turn it on.
Excuse me, that's illegal. Y'all can't
All right.
do that.
No, that's on now. Turn it on.
Yes, it is, Justice.
All right. So the offenses are non-dangerous. I'm finding them
Why are you allowing that?
I'm finding you're your own lawyer. He's not your lawyer. He's nothing can do it. I'm finding that they're non-repetitive because I believe that these cases, all of the charges in this case and in CR 2022-208, which is the prior case for which the defendant was convicted, these cases all those charges could have been brought together and tried together, but they weren't. I'm not criticizing the decision. It is what it is. It happened for independent reasons, but I'm finding that they are not repetitive. All right. So, Mr. Wagner, do you want to be heard on behalf of the state?
I do, Your Honor.
I refuse to proceed.
And if the victims wish to be heard, we have victims here in the courtroom, a victim, I think, I'm not sure.
No, Your Honor, she's outlasted the victims.
She's outlasted the victim. Do you wish to be heard?
The victims have had to return back to their homes in Oregon, and they're not here, which is a detriment to them. They had as much a right to be here as she did for sentencing, but she is her own attorney, and she's drugged us out long enough that the victims aren't here to give a statement today.
Wow. Did you just hear what the prosecutor said? And this is the goal of the sovereign citizen. It's either to prolong the court proceedings in order to get it thrown out. Judge gets tired, prosecutor gets tired. They give a sweet deal just to get this individual out of the courtroom. But here we see that she has drugged this thing out for so long that the victim's family, they're not even able to be in the courtroom to see the conclusion of this matter just because it's been drug out for so long, and they just did not have the time to be able to hang around and see this thing through. But this is the goal of most sovereign citizens. A lot of them don't believe in what they're saying. It's just a tactic to prolong and disrupt the court proceedings.
Right, so y'all can't do that. Y'all cannot force me. Y'all can't sentence me like this.
Ms. Blackshire, I believe that these are repetitive and that she should be subject to the Category 2 repetitive offender statutes. She committed these crimes. She was taken into custody for the first crimes, the 208, Your Honor. She was taken into custody for 208. She made bond and was released on bond. And then she committed these separate offenses while on felony pretrial release.
I just want to make clear, to save your words, I do intend to impose the enhancement of 2 years for the crimes being committed while on release. So I just want to...
All right, thank you.
If there was any confusion about that, I wanted to straighten it out. I apologize for interrupting you, but I thought it was something to clarify up front.
This is illegal.
I believe that it's more than warranted. She was sentenced. Those were separate cases. She was released from those cases, and she committed the new cases. Not only did she commit these crimes separately from the other crimes, these crimes significantly, especially the burglary, I believe substantially affected the victim. The victim, the owner of the property at Morningstar Ranch. Yes, she was burglarized before. No real property was taken from there. As you heard, you sat through both trials. But in this case, in this burglary here, count...
Let me out of here. I don't have to proceed with this. Move. I don't have to.
Count 4, Your Honor.
Let me out now.
The defendant confronted the victim at her home and has substantially affected the way the victim feels about her safety and security at the home, which I think is very important, Your Honor, to acknowledge that.
I'm sorry. I'm getting... What's that?
Are you going to allow
No, I'm talking to you. Why are you taking her up?
No.
You're not? Okay.
Because I don't want to be in here.
Staying in.
To leave.
Oh, you're bringing the chair in. Okay, that's fine. I apologize, Mr.
No,
That's fine, Your Honor.
I was getting signals from the defense.
That's fine. I also would point out to the court that the unlawful flight from law enforcement...
All right, stand by. Apparently they're going to restrain her and bring her back in. Thank you. All right. All right. Defendant is back. You may continue, Mr. Wagner.
Thank you, Your Honor. I would also point out to the court that count 1, the unlawful flight from law enforcement, and count 5, the resisting arrest counts, are not in any way connected with the prior the 208 case. They're separate victims there. These are definitely separate incidents. The state would argue that as well for count 4, the burglary, Your Honor.
No, I'm not relaxing. Y'all being a legal The court lacks jurisdiction over the subject matter. Y'all don't have no right. Get this shit off of me.
If I could have just a second, Your Honor.
I ain't never been fighting with y'all.
What's the statutory reference to the 2-year enhancement? I can't remember that.
It is, I'm sorry, Your Honor, it is 708D. And I don't know that I made that entirely clear, but it just, whatever the sentence, the court prescribes, each sentence gets a 2-year enhancement.
Is that ARS 13-708?
Yes, I'm sorry, ARS 13-708.
But not as to the misdemeanor, obviously.
Not as to the misdemeanor. I concur with the misdemeanor assessment that probation had, that it's just time served in the county jail, that she's already fulfilled more than the requirement for that. I agree that the presumptive terms are warranted in the other cases as well, Your Honor. I would point out that the jury during the aggravation phase, the jury found 4 aggravators. They found 4 aggravators. We have no mitigators here that I can see. Even with all of that, I would still ask for the presumptive terms as a Category 2 repetitive offender with the enhancements for the 13708D. I think that these charges probably would be warranted to run concurrent with each other, but I do feel that they should run consecutive to the defendant's prior case. She caused more harm and more emotional stress to the victim, the owner of the property, and then we have separate victims as to the resisting arrest charge and the fleeing from law enforcement charge, Your Honor. I don't have anything more to add than that, and there's no victims present. There's some representatives, some neighbors, some people from the Morningstar Ranch that are still living in the area. They're present here today just to watch, I suppose.
Very well. Thank you very much. All right, the court imposes a sentence as follows. As to count 1, unlawful flight, a Class 5 felony, the court, as I said, finds the offense to be non-repetitive, non-dangerous. The court imposes the presumptive term of 1.5 years in the Arizona Department of Corrections. The court imposes an additional 2 years sentencing enhancement because this offense was committed while the defendant was on pretrial release, and that's pursuant to ARS 13708D. So the total sentence as to count 1, Class 5 felony, is 3.5 years. As to count 2, this is the misdemeanor criminal damage. The court imposes a sentence of time served. As to count 4, again, the court finds this to be non-dangerous and non-repetitive. This is burglary in the 2nd degree, Class 3 felony. The court imposes the presumptive term of 3.5 years. The court also imposes the sentencing enhancement pursuant to 13708D of 2 years. So the total offense level, the total sentence for count 4 is 5.5 years. As to count 5, resisting arrest, it's a Class 6 felony, non-dangerous, non-repetitive. The court imposes the presumptive sentence of 1 year. The court further imposes the sentencing enhancement as required by law under ARS 13708D for 2 years, for a total of 3 years as to count 5. The court further designates that the sentence imposed on counts 1 and 5 are to run concurrent with each other. That is the unlawful flight and the resisting arrest. The sentences in counts 1 and 5 are to run concurrent with each other. The sentence imposed on counts 1 and 5 are to run consecutive to the sentence imposed on count 4, which was 5.5 years as to burglary in the 2nd degree. So the sentence imposed on counts 1 and 5 is to run consecutive to count 4. The court imposes the sentence imposed on count 4 in this case, which is burglary in the 2nd degree of 5.5 years, is to run consecutive to the sentence that was imposed in case number CR 22-2008. Right, so the sentence imposed as to count 4 in this particular case is to run consecutive to the sentence imposed in case number CR 22-2008. That's because this defendant was released in the prior case, 22-2008, when it was a justice court case. She was released when she posted bond on July 7th, 2021. She failed to appear and a warrant was issued for your arrest on October 20th, 2021. The events in this particular case are alleged to have occurred, I believe, on February 5th, 2022. So the events that happened at the Morningstar Ranch that were the subject of 22-2008, do you wish to have an attorney appointed to represent you on the appeal? If you cannot afford to pay one, the court will pay the costs of an attorney to represent you on appeal. That will include the costs of the lawyer's legal fees and legal costs. You will not have to pay anything. Do you wish to have an attorney appointed to represent you on the appeal? No. Appeals are specialized actions, and Court of Appeals is very sticky with their rules. They're very strict, and it's a real specialty with someone who knows how to write good appeals. I met with you before when you were here before, and we met not in chambers, but in the holding cell area. It's all on the record, what I'm referring to, and I advised you that it really is in your best interest, I believe, to have a lawyer represent you on appeal, and you indicated at that time that you don't want a lawyer to represent you on appeal. I'd really encourage you to do it. I think it's in your best interest, but it's your choice. Okay.
You said I need what with that?
You're excused. You're remanded to the custody of the sheriff to be delivered to the Arizona Department of Corrections to fulfill a sentence.
How much
What?
time?
Hold on a second. What?
How much time did you give me? You just said a whole bunch of numbers.
Yeah, you can take them. You're excused. Thank you. Good luck. All right. I'm not having the defendant step forward to sign for notification of her rights and to sign the judgment in this particular case. She's consistently throughout all the proceedings in the Justice Court and in this court as to whenever required to do so or asked to do so, refused to sign anything. So that would be fruitless to ask her to do that. But the record will reflect that I've advised her of her right to appeal, the right to have an attorney represent her on appeal, and I think that's all we're going to do. And I don't see any point in having her trying to sign these documents. That's just not going to happen.
I don't either.
I think it'd just be disruptive to the court proceedings. Okay. Anything else? All right, we're adjourned. Thank you all very much.
Miss Blackshire definitely was a handful for the officers here today in this court proceeding, just yelling out, upset. You know, they had to take the microphone away from her, take her out of the courtroom, and just her behavior in the courtroom shows how bad it had to be for the family that she was accused of harassing and being on their property. But hopefully Miss Blackshire does this time, and she got quite a bit of time. Hopefully she does this time, and while she's in there, changes her ways, gets out, stops the sovereign citizen stuff, and just walk a straight path from there, because this behavior, these ideologies is definitely not going to do her any good in the future, just like it did not do her any good in the present. But I look forward to seeing you guys soon on the next video. And whatever you do, don't forget, no one is above the law. See you guys soon.